Good morning, everyone. It is 9 o'clock, so I'm going to get started here with the civil docket in Barron Circuit Court. We only have 3 cases on this morning. We had a couple more that have been removed at the request of the movement, but I don't see anybody on here that those would affect. So I believe everybody got word of that. Moving chronologically, the first case I will call is 19 CI 769. That is, I believe it's Wayland's case. It's Wells Fargo versus AmeriCorps Lending Group. It is a motion for a declaratory judgment, basically on one of these mortgage assignments that got in the shuffle or didn't get where it was supposed to go, or I can't remember the exact facts, but I'm sure
that's correct. We have a bank that's now out of business, and we are missing an assignment from that bank. So we're just trying to get a declaratory judgment so we can get that mortgage released.
That shouldn't be a problem. And I have last week I looked through your pleadings. We'd been here once before because you were having trouble with getting a warning order warning order attorney report. And we resolved that, I believe. You did finally get that report, and everything looks like it's ready to go, and you appear to be entitled to the relief you are requesting. So there has been a proposed declaratory judgment tendered electronically, and when I wrap up with our hearings here in the next few minutes, I'll get on my e-filing and get that thing entered. Okay.
All right. Thank you, Your Honor.
All right. Anything else?
No, that's all I had today. May I be excused?
Certainly. Thank you.
Thank you.
I believe we have all of the necessary individuals for my next case, which is the estate of Bush, 20 CI 561. I think the main issue, we've had several different things kind of cropping up over the last couple of weeks, but I think the main issue, you all correct me if I'm wrong, is the Master Commissioner's motion, which seeks to have a portion of the proceeds from the sale of personal property allocated towards her fee. And I know there's been at least one, I can't remember how many, but I know there was at least one objection to that. So I think that's the only motion that's on the table right now. If there is another one, you all tell me and we'll figure out a order in which to discuss them. Oh, Mr. Hinton, you're on mute. I can see you valiantly trying to communicate with me.
Larry Hinton, Hancock Bank, or something I want to discuss after you rule on Cheryl's motion. It's just a housekeeping matter that I think the parties with liens are in agreement to.
All right. So you're not weighing in on the other at this point, right?
No, I'm going to let you decide what Cheryl gets paid without comment.
Oh, well, I guess I appreciate that. I don't know if she does. I guess South Central Bank is the one that, of course, that filed a pleading or a response. Is that right, Mr. Mixon?
Yes, Your Honor, and don't begrudge any attorney trying to earn any fees. I just kind of had to file something, and I'm just going to rest on what was filed. So
I understand. Mr. Davis, I would guess that if you wanted to file something, you would have filed something, but since you're on here, do you want to talk about this at all? I think maybe you're muted too.
Where did he go?
He's on mute if he's trying to talk. I can't tell if he is because his name is covering his mouth.
Okay, can you hear me now?
I can.
Okay, sir. I'm neutral with regard to her motion. I'm not opposing it.
Understood. So we have, looks like most of the precincts heard from here. Mr. Green, I guess you were involved in the case as well. My past experience with you would lead me to believe that you would know how to interject if you wanted to.
Your Honor, we'll follow the decision that's entered by this court.
So the, the upshot of it, as I see, is that it's a little, the commissioner's done way more work than would have to be done in your average case, even with the fact that there is a third-party auction service, based upon the amount of property that's getting sold and the size of the property in the estate. And of course, a lot of that was derived from the method required under the law to have the claims proved, which was, something that is not done in every case. And I don't know what Ms. Berry had to do to get ready for that, but I do know that we had a few different discussions as we went through about her just trying to even find what the right protocol for that to do, because most of the master commissioners that she was in contact with had never seen or heard tell of that sort of thing. And I think she ended up having to go all the way to Jefferson County to really find a lot of guidance on how to do that. So I don't mean physically go to Jefferson County, but reach out to Jefferson County. So, at the end of the day, my point is that she has done more work than one would normally have to do. And even if it is not in the form of actually physically selling, conducting an auction sale of personal property, I think that because of the different conversations that we have had regarding the narrow margins on some of these real properties in terms of what they might bring versus what might be owed on them, I feel like I need to at least kind of reserve the possibility that, that I'm going to have to do something a little bit out of the norm, because that's how this whole case has gone, to make sure that there is some money there for a fee. And she has done, in that proof of claim part, she has done a lot of the groundwork that got this case to even in a position to where we could be where we are right now. So the upshot of it is, I feel like it's inevitable that I'm going to grant that motion, although I have not given any thought, unfortunately, at this point, to what percentage, if I understand correctly, the kind of using the language kind of loosely, but I mean, there's 20% that you can kind of play with. The auctioneers are taking 10%. So to keep it within the statutory 20%, there's 10% that, that would be available to, kind of to play with in this situation. And I do not know whether anybody, if we assume that I'm going to grant the motion and the only question is to what extent, I don't know if anybody wants to be heard on that. My thought process was maybe just to wait and see how the real estate sales went before I committed to an actual percentage, just because I do not want to make it larger than it would actually need to be fair and to reflect appropriate compensation. But if I make it too small, then we're stuck with that. If I make it too large to a certain extent, I guess we're stuck with that too. So, I don't know if you all want to be heard on that, or I guess, Ms. Berry, I'd start with you and see if you had a percentage in mind.
I do not have a percentage in mind, but I do not expect to receive the full 10%. I believe that a portion of that 10% that's there needs to go back to the estate for various and sundry reasons, if there is an excess, and I would expect there to be. And as I said, I certainly don't expect the 10%. But once the order was received as it was, I'm going to be there and I will have to oversee it. And
Yeah, sure.
what was that?
I don't know.
I had Montgomery County on there for a minute.
Yeah, they're on the 10 o'clock docket, and it's always hard when people are on the fast time. We sometimes get them chiming in on the 9 o'clock docket. I go ahead and let them in so they don't think that they're in the wrong place.
I was looking at something in the neighborhood of 5% and down, whatever the court
Yeah.
would feel appropriate from there.
Well, what have we been doing? I'm thinking that some of these, or if not all of these other orders of sale, there's been some kind of holdback that everybody kind of agreed on. And was that 3.5 or 3? What was that?
3,
Matt,
3?
yes.
Yeah. So I
It
would
was
think,
3.
yeah, I would think that, at a minimum, just, I mean, I understand that a foolish
3 is,
consistency is a
court feels that's
hobgoblin of
appropriate,
little
it's
minds,
fine.
but I might stay with 3%, just to, or at least, say that it'll be somewhere, I mean, just to give everybody an idea, say that it'll be somewhere between 3 and 5. And then, I don't think there'd be anything wrong with entering an order that said, 3 to 5% would be the, could be allocated to the fee, and then we can make a more permanent decision after we see how the funds fall out. And
Your Honor, may I just say one thing? I've been sending emails around to a lot of people trying to not have hearings and motions, because we've more than normal foreclosures and estates. We've had many, many, many hearings. I represent Hancock Bank, that its sole collateral is this equipment. That's its sole collateral on its $28,000 loan. Now, it is inferior, absolutely inferior to the South Central Bank mortgage lien, and it's absolutely inferior to the Kentucky Revenue Cabinet lien, where Mr. Green represents the Revenue Cabinet. But what we're told is that Greenview Healthcare Facility is going to be paid in full out of a purchase. Now, this may or may not take place, a purchase of the facility. So that takes out the Revenue Cabinet. We also believe, and we did when the loan was made kind of on an emergency basis, that there was plenty of equity in the equipment, even though South Central was on first, because we thought they were oversecured on the real estate. And that's still what Hancock Bank believes. So what I was hopeful to do today was to reach an agreement. And I've had emails from a lot of people that I will circulate an order that basically says that the equipment proceeds, after the payment to the auctioneer and after payment to Miss Berry and the holdback, that will be held pending further orders of the courts as to distribution. And what I anticipate I would do is let it all sell, let Miss Berry hold the equipment proceeds. South Central Bank hopefully get paid out of all of their real estate. There should be some surplus to additionally pay the beneficiaries of the estate on some percentage, and Mr. Davis. But I was going to try to submit an agreed order that there would be that holdback, and Mr. Mexic had sent me an email that he was agreeable to that concept, and I think Austin had sent me one too. So, and it would be Cheryl, Austin, Darren, Tom Davis, and myself that would submit that signed agreement to the court.
Your Honor, I had that very idea in mind, that it should be just a holdback until the court can make decisions, because there are so many matters still floating around, and they can't be determined until the sales occur and we know what we're dealing with in terms of dollars.
Yeah, I agree. And there are a lot of these, this should happen. And, if things go okay, that will happen and that kind of thing. And we all know that, I know none of you all would be saying those things to me if you didn't believe that is actually what was going to happen. But occasionally we get surprised, even in this business. So I think that we would, I agree that we need to kind of keep from pulling all of the triggers until we know what's going to be happening. But Mr. Hinton, I don't see anything wrong at all with that order. It doesn't seem like anybody else does either. So if maybe you all could get that.
I'll try to get a draft out today and send it around. And it's just really the holdback for now. And I'd have to file a motion later to get whatever's left. Like if you gave Miss Berry 5%, did the 3% holdback, whatever you do on that, we understand you're going to take that out of the equipment before Hancock Bank gets paid.
Yeah, and my contemplation here is just to enter an order in response to Miss Berry's motion that says, you know, that it is granted and that there will be, she will be entitled to a fee out of the proceeds in an amount to be determined. And I may even just go ahead so I don't forget that at this point in time, I thought it was fair at least, maybe go ahead and say at a percentage somewhere between 3% and 5%.
Do you want me to put that in our agreed order as a resulting order today and save you the drafting?
It would help me, I guess, if you did that.
Okay, I'll put that in there.
Okay. Well, it would help Crystal.
But we
She'd
want
be-
to help Crystal.
She would be over here furiously trying to type it up in between all the hearings that we're going to be having today on the criminal docket, which are legion.
All right, and we'll admit the priority.
Yeah. All right. So are we at least up to speed on everything so far in this case that needs to be decided?
I believe so.
Nothing else from that case. All right. So
Sell a bunch of real estate.
Mr. Hinton, I won't do my own order. I'll just wait for your order and we'll go from there. Okay.
All right, I'll copy the attorneys while they're circulating, and then probably we'll let Cheryl send it over to you since she's there in Barron County.
Good deal.
All right.
I can take it electronically or you can bring it hard copy over, either one. Okay. All right. Thank you all.
Thank you.
Thank you.
Thank you, everybody.
Then we have 21 CI 74 Glenview versus Massey.
Yes, good morning, Judge. This is Alex Thomason for Glenview. This is our motion for partial summary judgment.
Okay. Miss Rector, I see, is on here. Miss Rector is with the state guardianship and probably was, I don't know, Karen, you tell me, but was probably the person that got sworn in on behalf of the state when Miss Massey got a guardian. Is that wrong?
Actually, Jim Schaefer was, but since she's at Glenview and that's my facility, I've been taking care of it. Your Honor, I talked with our supervisor this morning. We sold part of the property for $164,000. He has a check and it will be sent to Frankfurt today and we will be able to pay that bill.
Okay. So, you know, this is not something that I've ever actually seen is a deal where, and not that there's anything wrong with it, you understand, but I just didn't know. I'm sure that Karen has seen it because she's been in the guardianship business longer than 15 years, which has been how long I've been in the judge business. You'd think you would see most everything by 15 years, but I find out almost weekly that I have not. So, yeah. So I guess I don't really know what Glenview wants out of this at this point probably I would think they want a judgment and then they can just wait until they get that check from you and then do a release.
Your Honor, the Masseys were a couple and the husband died about 2 weeks ago. They were both in the nursing home. And this was probably a good thing because Miss Massey is not very well at all. And it's just in case they passed, then we could still pay, with the funds. But we do have enough to pay Glenview. Hopefully, I would say it'll still probably take 2 or 3 weeks, but I think we're going to get them paid.
All right. Well, what if I just, we just kind of say informally here on during the hearing that I can issue or enter the judgment that has been tendered. I would want to go back and look at it again just to be sure that it didn't say anything inconsistent with what we're talking about, but I don't think it does. And then the plaintiff maybe can just hold off for 30 days or something, not spin their wheels and do anything real hard because it sounds like you all are going to be able to get that paid and it'll be fairly painless for them to collect it, if they just get a check in the mail.
That'll be fine, Your Honor. This was really just a measure we were taking to stay protected a little bit. And I've been talking with Karen over the last couple of weeks, and we just wanted to get the motion filed and get a judgment entered just in case we need it.
Understood, understood. Well, Karen's a pretty square dealer. If you talk to her about something and she tells you something, she usually means it. Or at least that's my experience with her. I was in district court for 9 years and she was doing guardianships. And so we were felt like constant communication with all of those guardian cases that you had back then. And you're still doing it. So, all right, I'll get that judgment entered and that will, I think, probably take care of what we need to in this case. Then you can just kind of hang out and wait for that check to come in.
Thank
Very
you all
good.
so much.
All right, thank you.
Bye.
Bye-bye. So Crystal, this is what I'm going